Justice Perry, first of all, I'd like to thank you very much for your agreement to participate in this interview process on the very important subject of merit selection and retention. So I'll start with a very basic question and ask you to explain what merit selection and retention is, when it first came about, and what it replaced.
It first came about during the time that Reuben Askew was the governor of the state of Florida. Apparently there was a lot of corruption in the court. A couple of court members had been, I don't know whether they were threatened to be removed or were going to be removed, but there was a lot of corruption, and there was an opinion written by one of the participants in a suit for the justice. Apparently they collaborated on the golf course, and he handed him an opinion to be circulated, and apparently that opinion was circulated, and it was detected that the opinion was written by somebody other than the law clerk, and that's when, you know, of course, and at that time the court was, well. And that's when the bottom fell out, more or less. But there was obviously a lot of corruption in the court, and the whole purpose.
Those were the days when judges were elected.
They were elected, precisely. The judges were regular politicians that had current political favors from other people, and that people who brought them to the race and who supported them financially, they held a certain amount of allegiance to, and they were partial. And they were loyal to the money that brought them to where they are. Merit retention was a mechanism set up so that the judges would be vetted through a Judicial Nominating Commission, and they would submit names to the governor, and the governor would pick from the 3 or 6 names, and that's how it came about. And also the makeup of the commission wasn't necessarily made up of the governor's cronies. They were independent, and they tried to select the best people to serve the people of the state of Florida.
Now, in November 2010, you and now Chief Justice Labarga were on the ballot, where the voters essentially had the right to decide whether you should remain on the court or whether you should be removed from the court. Would you tell us about the organized political campaign that was waged against you both, and what prompted that campaign? Why there was a movement to get rid of you and Justice Labarga?
I think we were probably on the tail end of what happened in Iowa, where at the last moment there were the influx of out-of-state money into the Iowa state races, and they blanketed the airways in Iowa. Iowa's a small state, and you know, several $100,000 would probably cover about most of the media time. And these judges were removed because of a case they decided that involved what did it involve? Same-sex marriage, precisely.
Okay.
Right. Well, they said it was, basically they didn't say it was okay. They simply said it didn't stand constitutional muster. And as a result, there was a concerted effort by the religious right and other right-leaning organizations to remove them, and it worked. They even removed their spouses who were in other elected offices. It was just a sweep. So apparently that's where the impetus came from in Florida, and they decided, although we hadn't decided any cases like that, but they thought perhaps if it were to come before them, we might stand with the Constitution. And of course, they decided they didn't want us in. And there was a guy in Orlando that started this, I don't know his name, he's a small-time guy. But he started it, and it picked up impetus, and one of the parties, I guess I can say the party, decided to back them in a surreptitious manner. They would send emails around, and they would send even to the sheriff in Duval County. He recirculated the email to tell their people not to vote to retain Justice Labarga and I.
was pretty revolutionary in the sense that in the vast majority of retention cases involving appellate judges, the vote is that they be retained.
Always.
And here were 3 justices that were thrown off the court. What was very surprising about the Iowa situation is those 3 justices decided not to fight it. In other words,
Precisely.
They did not make speeches, they did not contact the media, they did not get the Bar Association. And how did your situation differ from that?
Well, we were aware that we might come under attack, and we first saw this, it was a blog or something, and then we knew they were holding meetings throughout the state, and we were trying to wait to see whether or not it would gain any great support. We didn't detect that it would generate a lot of support, and we were aware of it, and we tried to make people aware informally, but we didn't mount an official campaign. We didn't raise any money. I talked with the media about it when asked, and to try to, basically I told them we were like sitting ducks. We were sitting here waiting to be plucked off, and but we didn't mount an official defense.
In 2010 was vastly different from the situation
It was.
in 2012 with Justices Pariente and Lewis on the ballot, where I think the Florida Bar got very, very involved in that.
Well, in 2012,
and Justice Quince, of course.
there was a frontal attack unprecedented by the Republican Party. They officially declared war on the court. So because of that, they had official, strong opposition, so they could mount a defense. And in that regard, the lawyers and bars and people who understood the separation of powers stepped up to the plate to defend them. They raised an unprecedented amount of money, and they were able to ward them off. I think they received over 60, close to 7% of the vote. The people in the state of Florida understood what was going on, but they had to institute a serious defense. I mean, they were all over the state campaigning, and you can't raise money, but you can set up committees to raise money. I mean, it's kind of like, we're not politicians in the sense of the word, but we are elected. And the other side can spend as much money as they want, defaming you and et cetera. And we can only talk about who we are and what we've done. We can't talk about any cases and et cetera. Because they cherry pick a case that might have happened 10 years ago and some decision they didn't like, but that's not the purpose of merit retention. They obviated the whole purpose of merit retention. The merit retention was supposed to allow for judges to be independent of any kind of pressure from political, financial, and otherwise. And it seems as if the trend in this country is changing, and that will undermine democracy. And the French had a constitution that was much better than ours, but it did not allow for an independent judiciary. And that's why the French Revolution came about and overthrew them. And here, I can see the same thing happening with decisions of the U.S. Supreme Court regarding funding and special interest groups outside. Special interests who wanted to basically control the court. It's interesting that in North Carolina, I don't know whether I should talk about this or not, but anyway, I'm going to talk about it. And it was appalling. I'm a native North Carolinian, and in the last election, the chairman of the Republican Party came to my hometown, and he was lamenting that, he was bragging that we control all 3 branches of government. And you know, the first 2 branches, executive and the legislative, are political. The will of the people should dominate, and the purpose of the Supreme Court is to protect the poor from the rich and the rich from the mob, and that's basically, we should do that in a manner that stands constitutional muster. We're not supposed to be swayed by politics or the threat of money or et cetera, but we're not supposed to be a political branch, and we aren't, for that matter. But certainly the temptation there, and the public's perception might be that justice is for sale.
Do you see this as a national trend where these political groups on hot-button issues such as abortion, the death penalty, Obamacare, same-sex marriage, and it seems so unfair because someone can be sitting on a court for 20 years and these groups zero in on one case, one decision, and say throw the guy off because of that one decision? Well,
in my opinion, that's a head fake. It's really not about that. It's simply about controlling the judiciary. It's almost like in Grisham's book about how they control they just bought the courts because we decide important issues that could affect industries, the way people live, caps on tort reform, you name it. So that's just a subterfuge. That's just a wedge issue that they put out there to draw people together who really vote against their interests in the long run. Because we have no real control. Mainly those are federal issues that we don't really decide. But it's not about that. That's the head fake and an effort to fool the people, to vote against their interests, and to diminish democracy. Because the three branches of government is like a three-legged stool. I mean, if one leg is cut off the stool, it's going to topple over. And what is holding up is democracy. And that's a very serious issue. It's not just politics as usual. It's not about ideology. It's about the future of our country. And I think we're the strongest country in the world. I've traveled all over the world, and I love this country, but the only thing that can hurt this country is us. We can fall from within. I don't think that outside ISIS or anything like that can topple us, but we can topple ourselves.
Do you think, for example, there ever would have been a Brown versus Board of Education decision if the justices were subject to merit retention?
Of course not. I mean, let's face it. I mean, the justices were independent. Now, some of those who appointed them didn't like the decisions. As a matter of fact, I'm told that President Eisenhower said the worst decision he made was to appoint Earl Warren. Precisely. I mean, but that's the whole purpose of justice, is to mete out justice, not the will of the popular. I mean, if they wanted to, during the Brown decision, of course, it overthrew Plessy v. Ferguson, which was decided in the late 1800s, I think 1886, to be exact. And they didn't like that, and they called them activist judges. That's where this term activist judges came from, because they didn't follow the precedents of Plessy v. Ferguson, which was flawed from its inception.
I know that when you were first appointed as a circuit judge, a trial judge, a Republican governor, Jeb Bush, appointed you, and another Republican governor appointed you to the Florida Supreme Court, Charlie Crist. And I understand he took a lot of heat from that appointment. Could you tell us some of the inside background on that?
Well, I've read his book, and I knew a lot of what he wrote about in his book. I don't know all the details, but it's my understanding that there was a hedge fund person from New York, Wall Street, who offered him a substantial amount of money not to appoint me. Through the back channels, I heard that amount was $1.5 million for him not to appoint me. And he did. And the day after he appointed me, I'm told that the money went to his Senate opponent.
Really stood up to a lot of temptation and pressure.
Well, I didn't know Governor Crist prior to the appointment. Never talked with him, never had a conversation. My only conversation with him was during the interview. and based on my background, I never expected to get in. My job, I went to law school to fight for freedom and equality for all the citizens of this country. So I understand when people kick doors down, they aren't let in. So I never expected to be let in. So being a judge or justice never was one of my expectations.
I know that you went to Columbia Law School in New York, and you did not do what most of the graduates of Columbia Law School do at that time and presently, where they go to work for Wall Street law firms for big money. And tell us about what you did in the state of Georgia after you graduated from Columbia.
Well, you're right. Columbia is known as a corporate law school. Everybody expects you to go on Wall Street, and you're almost guaranteed a job on Wall Street if you have that degree. And in the 70s, when I graduated, they were paying $30,000, $35,000 a year. That's a lot of money. The dean called me to his office in the third year and said, Mr. Perry, I see you haven't applied for a job on Wall Street. Mr. Dean, I didn't come to law school to work on Wall Street. I came to gain experience, to come back to the South to fight for equality and justice. And so I drove down to North Carolina on my spring break of my third year law school. Matter of fact, I applied to take the North Carolina bar exam a year before it was given. Because in New York, you have to apply for 9 months before it was given. Didn't know any lawyers, didn't know anything about law prior to attending law school. So I drove down to North Carolina to seek some kind of a place to exercise, utilize the I was a Reginald Hubert Smith Fellow. That's the name of the fellowship. It was a 2-year stipend. And I could go wherever I wanted to go. So North Carolina was my state of choice because that's where I was born and raised. Never been south of North Carolina. I get down there in Charlotte, and I'm talking with Julius Chambers, who was a civil rights lawyer, and he was just all-around good guy. He worked with Jack Greenberg, the Legal Defense Fund. He was a corporating lawyer. And he and his partner, Ferguson, don't remember his first name, but they told me that North Carolina had a rule that you had to apply in your first year of law school, or you had to wait 27 months to take the bar exam. So I immediately got in my car. It was a Friday afternoon. I drove down to Greenville, South Carolina, and I went to legal aid there, and they said, well, we don't have such a rule that we have, you can take the bar right away, you don't have to wait. And so I said, great. And they said, well, but we haven't passed an African American in 7 years. And we have a rule that if you take the exam, fail the exam 3 times, you have to go back and obtain a master's degree. And most blacks had taken it twice, were afraid to take it the 3rd time. So I said, that's not gonna work. And they didn't want to sue anybody. So I decided, got in my car and drove down to Atlanta. Never been south of North Carolina before. Maynard Jackson was the vice mayor at the time. Didn't know him, had never met him, didn't have an appointment, knocked on his door, office door. He had a 7-person law firm, and he said, Georgia doesn't have such a rule. He said, we normally pass 3 blacks a year. The one that went to graduate University of Georgia, Emory, and one other. Says, best news I've heard all day. Perhaps I could be that one other. So I picked up, he had a map on his wall that said, why don't you come to Atlanta? I said, well, I don't really like big cities, all this traffic in Atlanta. I mean, it reminds me of New York. And so he looked at a map on the wall, and I picked Augusta, Georgia. Because Augusta, my thinking was, it was right on the border of Georgia and closer to North Carolina. And it was 125 miles through interstate to Atlanta. And it had the University of Georgia School of Medicine, Payne College, Georgia State, Fort Gordon Military Base, and I thought it'd be a good location. And there were 2 black attorneys in the whole state there. At the time, there were 38 black attorneys in the whole state. 32 of them were in Atlanta. So I go back to New York after I pick my locale and graduate and come back, take the Georgia Bar Review course at the University of Georgia, me and 40 other blacks. And we set for the exam in June of 1972. That's the first year of the multi-state. We go back home and wait for the results. Two or 3 weeks later, results come in, and I failed. So you lament for a week or two, and through slight depression because you're not used to failing. And so you call around to see what 3 passed, and found that they didn't pass any of us. Every single African American failed the exam. The one that went to the Harvard, Yale, Columbia, Notre Dame, top law schools in the nation, some members of bars in other states. They said we passed they said I passed the multi-state portion, but I couldn't pass the Georgia portion. So anyway, I called Jack Greenberg, one of my professors at Columbia, who was the chairman of the Legal Defense Fund, NAACP Legal Defense Fund, and he sent Elaine Jones down, and I called a meeting of the other applicants in Atlanta, because that's where most of them work for the majority of law firms in Atlanta. And we met there, and I proposed the idea of filing a lawsuit against the bar examiners because something was amiss. Had they passed 1 or 2 of us, we might have thought, well, maybe we were just dumb. but I mean, and they passed like 750 whites, graduates of John Marshall Law School, Knight School. I mean, it's just amazing.
Knew that result couldn't be
well, I mean, you had to submit your picture with the application. You sat at the same table for 3 days. There's a number on it, and so I mean, you know, I knew it didn't seem right. If it walks like a duck, quacks like a duck, it's probably going to be a duck. But anyway, I didn't give it a name. So the suit was filed, and I could only get 16 of the 40 blacks to participate because they were afraid. I guess having served in the military as an Army officer, and I was subject to go to Vietnam to be killed, my reasoning was, well, they can't send me to Vietnam, whatever they do. So my sense of mortality was right in front of me at a very young age. And I guess they call it courage, but I call it I didn't see a choice. They don't want to allow me to work. And then that's why we went to law school, to traverse the legal system and get just results. Well, I sat for the exam again in February 1973. And they passed 11 of the 16 plaintiffs, including me, and 13 others. They passed 24 African Americans. That June, they passed 24 more African Americans. So we doubled the size of the Georgia bar in 1 year. Now, I don't know whether that was racial discrimination or what, but I mean.
That was an extraordinary accomplishment.
That was very extraordinary, and I don't believe in coincidences.
Some of the people who say in general that merit retention is good, but they say there has been a criticism which they think is not politically motivated, where they say that in a sense it's a different form of politics because the judicial nominating commissions can become political, where the governor has a tremendous amount of power in appointing people to serve on the Judicial Nominating Commission, and ultimately they give the governor 3 names and he chooses one. How do you feel about that?
Well, I mean, we live in a political country. Everything has some semblance of politics. I mean, to say that's not true is to put your head in the sand and just the epitome of naivete. But what the Judicial Nominating Commission does, it vets the people. And it's a fair vetting. There have been instances of politicking with the Judicial Nominating Commission. I was a victim of that when I applied for the circuit court position. I applied 3 times there, and I couldn't get out because they would. I would get enough votes. I'd be the 4th one, and they'd say, "Well, let's send 4 names. You can't send up to 6 names." So they voted 5-4 to send 3 names, and 5-4 not to send me. And then there were instances where the person they sent would be a dud. The 2 people they sent, the person they want they would send, and then the other 2 would be duds that knew the governor couldn't appoint them, and therefore the governor really didn't have a choice. So that has been known to happen, but of late, I'm sure there's some politics in everything. I mean, this is America.
Unavoidable.
Unavoidable, but some people have have the integrity at least to vet the person, and I've noticed that hasn't been happening lately. Normally, they send good candidates up, but that beats the electoral process in my estimation because the people aren't vetted, and most people, most Americans, most citizens of Florida know nothing about how the judiciary is formulated, what we do, whether these people have records or not. And it's been my experience that most of the people who have trouble with the bar, judges, etc., are those who were elected and not vetted.
That even in retention elections, where there's no controversy and there's no organized push to get rid of anybody, historically, about 30% of the electorate vote to kick the judges off. Where do you think that thinking comes from? Because obviously the average member of the public has no idea whether a judge is a good judge or not a good judge, unless it's...
Well, I think in my election year, and I don't know whether it's still held in 2012, 500,000 people who voted for the top of the ticket did not vote for judges. And also, the panhandle area of the state always vote. We never carried any, well, we carried very few of the counties in the panhandle. They always vote to kick everybody out. I mean, it doesn't really matter. They want all justices kicked out. I think the only ones I carried Leon, Madison, Quincy, and Jefferson, and the rest of them overwhelmingly voted to kick everybody out, including the conservatives.
You know, Justices Quince and Pariente and Lewis have participated in this discussion about merit retention, and Justice Pariente said that it became so tense and so aggravating that she suffered many sleepless nights. Judge Lewis said that he had like a stone in his stomach for over a year with everything that was going on. How did it affect you personally in 2010, when you thought there was at least a possibility that you might be removed from the court?
I guess my life experiences were different than theirs, perhaps. I might have been, having the military background, having been brought up through civil rights, not really having a lot of expectations of the system. My attitude was whatever will be, will be. I had a life before I was on the court. Being a member of the Supreme Court was not a lifelong dream of mine. I was asked to apply. I was asked to apply for a judgeship. I mean, so it wasn't something I always wanted to do. It's an honor, don't get me wrong, but it's not, this is what I do, it's not who I am.
Yeah, you know, you've been a lawyer. You were in private practice, very, very successful. You were a trial judge for how many years?
9.
9 years, and now you're on the state's highest court. Which, on a personal level, has given you the most satisfaction, do you think?
I guess on a personal level, my greatest satisfaction was on the trial court. I presided when I was chief judge. Nobody wanted to serve on the drug court, and I appointed myself. And it was the most gratifying experience I've ever had. Where else can you, when you turn people who are drug addicts, facing prison, dredged on society, torn families, and when they graduate, in 18 months they tell you, you saved my life. I mean, what is more gratifying than that? And that to me was transformative in terms of what we should really be about. People they had to work or go to college to get a job, and they had to take care of their families. They weren't a dredge on society. And I think, and that was when they called us tree huggers then, because we wanted to, I guess they considered it coddling criminals, but they weren't criminals. Nobody wakes up in the morning and when they are born and say, I want to be a drug addict. I mean, that just doesn't happen. It's just like high blood pressure, or any other illness, and we should treat it like that instead of criminalize it.
Do you think that somehow, in view of the political climate and the various attacks on judges, and particularly with what happened in Iowa, should judges be granted wider latitude to defend themselves? I mean, to directly defend themselves?
I think that's probably where it's going, where it's headed, in terms of what's trending nationally. It should be a fairer fight in terms of judges
That's
being
what I mean
able.
when you say sitting duck, or you know, they can just take pot shots.
Precisely, and you can do nothing.
And you can't say, you know, I've decided for 600 other cases and no one complained, and you're picking one case, and you can't say that.
Can't say it.
And
Precisely.
that would we're down to the average person voting. Say, what's going on?
Well, you know, that's the way our system is, and I guess it goes back to the foundings when Washington and Jefferson and Adams ran for the presidency. It was considered beneath their dignity to campaign, so they didn't campaign. And I guess that same approach has carried over to the judiciary. Of course, in the federal judiciary, you don't have to. It's a lifetime appointment. But we've sort of taken some of the culture of that and transformed it to the judiciary in the state. And every 3 years we're up, every 6 years we're up, and people have a chance to vote us in and out. Traditionally, they hadn't paid much attention to it, but because of the importance of the decisions that we render in the court, special interests know that it's easier to elect 7 judges than, 200 state legislators?
Any other threats looming in the political arena which are directed really at judge intimidation to impair the independence and impartiality of appellate judges?
I mean, yeah, of course it's looming. I mean, power corrupts, absolute power corrupts absolutely. And it's really about power, it's not about the people. My position is it should be for the people and not about the power. And that's why we're here, to protect the powerless from the people with power. And the people with power, they don't want to have any opposition. I mean, that's human nature. I understand that. You know, I guess Florida politicians are some of the, historically have been some of the they could hide the ball type proposition, where they don't really tell you what they're doing, but you look at the results. And I mean, for instance, during the times when cases came before the Florida Supreme Court involving African Americans, the judges would turn their back. I mean, that was very, they read the newspapers. And that was very in your face. Now they're more subtle. I mean, they don't say it, but the innuendos are there. If you go for the head fake, you never see it, but it's there. They use code words. I call them buzzwords, dog whispers that the dogs can hear, and if you aren't aware, you won't hear it. But the dogs know what's going on.
Of course, federal judges, U.S. Supreme Court, and Brown versus Board of Education, they have lifetime appointments, and the only way to get rid of the federal judges through impeachment is that. Do you think that would be preferable for state judges? I think it would. That would be my preference. Well, even in Brown, if you study that history as I have, and you probably have too, I mean, it wasn't. I mean, a lot of things had to happen. Some people had to die. I mean, divine intervention, in order for Earl to be appointed, because it never would have happened, because a lot of those justices were parents were slaveholders, and they were segregationists also.
And that's the reality of this country, and that's the reality that we haven't really dealt with, that's still looming there. And this discussion that needs to be had. It's not a very comfortable discussion. I don't think it needs to be a discussion of one where you point the fingers or making anybody feel guilty. It's just a realization of what it is, and you can't sweep it under the rug. It needs to be dealt with head on.
In 2012, when Justices Quince, Pariente, and Lewis were on the ballot, you would agree that the Florida Bar and the justices themselves did a pretty terrific job in terms of just educating. They couldn't be partisan, of course, but they did a very good job in educating the public on how important it is to have the how different the judiciary is from the other two branches of political government, and it worked.
Absolutely. Well, I wrote an op-ed. I don't know whether you read it or not.
On the three stools.
Yeah, but I was told that I should sit this out, and I said, if not me, then who? If not now, then when? I mean, justice was under attack. What happened to us was unprecedented. A nonpartisan election, a party jumps in on one side, and I think when you have emergencies, you take emergency actions. You don't just let the status quo go on for presidential sake. I mean, there's a difference between a prayer meeting and a bear meeting.
The rest of your editorial was exactly what?
It was educational, explaining the responsibilities of the branches of government and how they should be independent, but they're interdependent and they work together. And it's about checks and balances. And when you don't have those checks and balances, you have dictatorships primarily.
I've just about run out of questions. Is there anything that that I haven't asked you that you would like to add or expand upon in terms of merit, selection, and retention?
As you know, merit selection and retention is coming under attack throughout the nation. I mean, you see, the problem is it's not just a local Florida problem. I call it local because it's not small, but this is a movement. This is the think tanks are set up to put forth policies, and it's given to legislators throughout the state. I think it's the co-opting of the American process on a state-by-state basis, and there needs to be a countervailing group to thought that. I mean, the monies, they have these innocuous names. But you don't really understand what they're trying to do, and it's clear to me what the objective is, and the objective is to thaw out democracy, and it's not a party issue. It's a public people issue.